Hello and welcome to the Street Crime UK YouTube channel. Please don't forget to like, share, comment and subscribe. Today we're going to take a look at the history of a notorious crime which happened in Sheffield, which will never be forgotten about in the UK criminal underworld. 4 gang members were jailed for a minimum terms of up to 35 years for the cold-blooded murder of a 17-year-old youth. Tariq Chabob was gunned down during a feud between fractions of a gang in Sheffield, the jury had heard. Tariq was carrying a gun when he was shot dead in the Burngreave area of the city in July after leaving a barber's in broad daylight. 2 members of the S3 gang laughed and joked with each other as sentences were handed down by Mr. Justice Griffiths Williams at Sheffield Crown Court. Nigel Ramsey and Michael Chatu smiled and exchanged remarks as the judge told Mr. Ramsey he must serve a minimum of 35 years of his life sentence. Mr. Chatu, who had at first refused to stand up to be sentenced, was told he must serve a minimum of 30 years. The 2 other gang members, Denzel Ramsey and Levan Menzies, were given minimum terms of 25 years and 20 years respectively. A jury of 6 men and 6 women found the 4 men guilty of the murder after a week of deliberations. Mr. Chatu, who was 21, and Nigel Ramsey, who was 23, and his brother, Denzel Ramsey, who was 20, as well as Mr. Menzies, who was 17, all had denied the allegations, but they showed no remorse or emotion when the woman foreman of the jury returned the guilty verdicts. However, Nigel Ramsey and Mr. Chatu both laughed in an act of clear defiance as the judge returned the sentence. The group chanted and shouted as they left the dock. Outside the court, 2 women were later arrested amid scuffles with the police and bystanders. The judge told the defendants, "Britain is not broken, although certain communities are plagued by the lawless activities of the likes of you and gangs such as the S3. I make it clear that to protect them, the full rigour of the law must be brought to bear, and rogues like you must be brought to the book," he said. 17-year-old Tariq Chabob, with his life ahead of him, was gunned down in broad daylight. Whatever his imperfections, and the evidence suggests there were many, that was a waste of life, and there remains a family and friends who mourn him. The jury heard how Tariq was blasted to death with a shotgun in a cold-blooded execution as people went about their business on a normal Friday. The murder was ordered by Nigel Ramsey, known as the General, from his prison cell by a mobile phone. He was killed after being branded a traitor by the S3 gang, who turned on each other in a violent civil war between the both fractions. Tariq had a foot in both camps of the S3 gangs in Sheffield, named after the postcode of the district of Burngreave and the Pittsmore area. But Tariq had been blamed by one side for allegedly crossing them by helping to carry out a knife attack, and paid with his life, the jury was told. The teenager himself, who was carrying a handgun, was at Frenchie's barbershop on Spittle Street in Sheffield around lunchtime on July the 11th, when he was blasted in the back from close range with a sawn-off shotgun, a pump-action Beretta shotgun. Just 5 days earlier, Tariq had been stabbed in the legs and body by Mr. Chatu, who was 21, and a 5th defendant, Javan Galloway, who was 20. Mr. Chatu, Mr. Galloway, and Nigel Ramsey were also convicted of an attempted murder in relation to the stabbing. Mr. Chatu and Mr. Ramsey were given indeterminate sentences for public detection with a minimum of 6 years to run concurrently with their life sentences. Mr. Galloway was jailed for 9 years. 5 days after he survived the stabbing, Tariq was at Frenchie's barbershop when 3 hooded figures, at least one carrying a gun, appeared from nearby flats, the jury was told. Tariq took out a black handgun, and eyewitnesses described seeing him face the others holding out his right hand, with one of the hooded figures also holding out his arm, both as if they were holding guns. Detectives failed to identify which one of the defendants actually shot Tariq, but the judge was told he was sure it was Mr. Chatu. On Friday the 25th of March 2011, we heard renewed applications for leave against appeal against convictions by 4 young men, Michael Chatu, Nigel Ramsey, Denzel Ramsey, and Levan Menzies. In the case of Nigel Ramsey, he also applies for an extension of time of 6 months in which to renew his appeal for leave to appeal. The single judge refused leave to appeal in all cases. We also heard 2 appeals against the sentence by Nigel Ramsey and Levan Menzies. In those cases, leave to appeal against sentence has been granted by the single judge. In addition, we heard the appeal against the sentence of Keisha Midley Donaldson. Conclusion of the hearing, we announced that Nigel Ramsey's application for an extension of time would be granted, that leave to appeal against conviction would be granted for all applicants on one ground of appeal, and that leave to appeal would be granted to M. Chatu. On one further ground of appeal, leave in respect of the remaining grounds was refused. We dismissed the appeals against sentence of Nigel Ramsey and Keisha Mindley Donaldson. However, we allow that of Levan Menzies. We said that we would hand down our reasons at a later date. These are our reasons. All members of the court have contributed to this judgment. On the 7th of August 2009, after a trial before Griffiths Williams Justice and a jury in the Crown Court at Sheffield, Mr. Chatu and Mr. Ramsey were convicted of the attempted murder of Tariq Shabab, whom we shall refer to as TC. That charge arose from TC being stabbed on the 6th of July 2008. A co-defendant, Javan Galloway, was convicted of the same offence. The prosecution case was that the stabbing had been ordered by Mr. Ramsey, who was at the time a serving prisoner, and that those involved in the stabbing were Mr. Chatu and Mr. Galloway. That offence comprised of count 1 of the indictment. Although TC was seriously injured, after he had been to hospital for several days, he was discharged on the 9th of July 2008. But on the 11th of July, at about 1:46, he was shot dead outside a barber shop on Spittal Hill in Pittsmore, Sheffield. He was 17 years old at the time. On the 7th of August 2009, after the same trial, Mr. Chatu, Nigel Ramsey, Denzel Ramsey and Mr. Menzies were all convicted of the murder of TC. That was count 2 of the indictment. The prosecution case was that Mr. Ramsey had also ordered that this killing take place. The prosecution alleged that Mr. Chatu, Denzel Ramsey and Mr. Menzies were all present during the shooting. Griffiths Williams Justice sentenced the applicants as follows. Mr. Chatu was sentenced to imprisonment for public protection on count 1 with a minimum term of 6 years. That was to run concurrently with the sentence of imprisonment for life on count 2. The judge fixed a minimum term of 30 years pursuant to the section 2692 of the Criminal Justice Act of 2003. Nigel Ramsey was sentenced to imprisonment for public protection with a minimum term of 6 years on count 1. And life imprisonment with a minimum term of 35 years on count 2. Denzel Ramsey was sentenced to life imprisonment on count 2 with a minimum term of 25 years, and Levan Menzies was sentenced to life imprisonment on count 2 with a minimum term of 20 years. The co-defendant, Mr. Galloway, was sentenced to 9 years detention on count 1. On the 12th of October 2008, Keisha Mindley Donaldson pleaded guilty at the start of a subsequent trial, which arose out of events giving rise to a trial out of the first 4 applicants before us. She pleaded guilty to 2 counts of assisting offenders, namely Mr. Chatu, Denzel Ramsey, Levan Menzies and Javan Galloway, with intent to impede their apprehension or prosecution. Other co-accused pleaded not guilty, and a trial ensued before Mr. Justice Keane QC and a jury. At the end of the trial, on the 28th of October 2008, Keisha Mindley Donaldson was sentenced by Judge Keane to a total of 4 years imprisonment. Purposes of the applicants for leave to appeal against conviction. We need only to give an outline of the facts. In Sheffield in 2008, there was a gang known as the S3 gang. It was named after the area of Sheffield in which it operated. There was an internal strife in the gang, and one faction murdered a member of the other faction, who was called Brett Blake. The 2 Ramseys, who were brothers, are also cousins of a young man called Junior Liversidge. Mr. Chatu was a friend of Mr. Liversidge, and Mr. Galloway is Mr. Chatu's cousin. Levan Menzies lived next door to the Ramseys. All of them were members of the S3 gang. Shortly after Mr. Blake's funeral, Mr. Liversidge was stabbed by associates of the murderers of Mr. Blake. TC had a foot in each of the rival camps of the S3 gang. Prosecution case was that Nigel Ramsey had wanted TC to be killed because Nigel Ramsey believed that TC was responsible for identifying to the opposite camp in S3 the whereabouts of Mr. Liversidge on the day he was stabbed. So Nigel Ramsey ordered, encouraged or persuaded Mr. Chatu Denzel Ramsey, and Levan Menzies to murder TC. The first attempt, which failed, was a stabbing on the 6th of July. The prosecution case was that on the 11th of July, Mr. Chatu, Denzel Ramsey, and Levan Menzies had gone to a barber's shop on Spittle Hill where TC was seeing a friend, and he was shot there with a sawn-off shotgun. The judge found, for sentencing purposes, that Mr. Chatu had shot TC, and the judge found as much when he was sentencing Mr. Chatu. One witness said that there was a second weapon present, although it was never established who, if anyone, had it on him. The murderers of Brett Blake had been convicted by the time of the trial. So also had the attempted murderers of Mr. Liversidge. On the 23rd of July 2008, a single-barreled 12-gauge sawn-off pump-action Beretta shotgun was recovered by the police from Oscarthorpe Park in Sheffield. It was examined by Dr. Mark Robinson, a forensic ballistics expert. In the gun was a Liovolve Magnum maximum game shotgun cartridge, which was loaded with a 50-gram load of a #1 shot. The evidence of Dr. Robinson at the trial, which was read to the jury and was not challenged by the defense teams, was that this type of pellet has an average weight of 0.25 grams, whereas the normal weight for a shot of this type is heavier, usually 0.28, 0.31 grams. Dr. Robinson therefore considered the weight of the shot in the cartridge to be lighter than usual. The weight of the shot pellets recovered from the body of TC at the post-mortem was also about 0.25 grams. Pieces of shotgun wadding that were recovered from TC's body were also the same type as that found in the cartridge recovered from the sawn-off shotgun. Dr. Robinson considered that the marks on the base of the cartridge that was also discharged into TC's body were indicative of having been fired from a sawn-off shotgun. He also considered that the marks were similar to those produced when he fired similar cartridge from the recovered gun. Police recovered from 97 Norgreave Way, where a taxi had taken Mr. Chatu, Denzel Ramsey, and Levan Menzies shortly after the shooting, 6 12-gauge Liovolve Magnum Maximum Game 1 #1 shotgun cartridges, which were, in Dr. Robinson's view, identical to the cartridges recovered in the gun. The shotgun pellets in the cartridge weighed 0.25 grams, and the wadding was that of the same type as that recovered from the body of TC and the cartridge found in the recovered gun. Dr. Robinson's evidence at trial was that this type of cartridge was encountered less frequently than other types of that shot in reference to the data of National Firearms Forensics Intelligence Database. The prosecution's case, as set out in paragraph 77 of its draft written opening, which we were told reflects on how the case was put to the jury, was that there was a link between the cartridges recovered and the cartridges that killed TC and the gun that was recovered. This was said to be particularly forceful because a DNA sample recovered from the cartridge in the gun that matched the younger brother of Levan Menzies, who lived with him. The prosecution said that all this provided a conclusive tie-in between the gun and Mr. Menzies and the other two accused of being at the murder scene. We first deal with the applications of Nigel Ramsey to extend the time in which to renew his appeal for leave to appeal against conviction. The applicant was convicted on the 7th of August 2009. Leading counsel advised on appeal and the application for leave to appeal conviction, and sentence was lodged in time. The single judge refused permission to appeal on the 3rd of March 2010. Notification of that refusal was sent to the applicant on the 31st of March 2010. The application to renew was lodged on the 2nd of November 2010, some 6.5 months out of time. The rules in relation to renewing application refused by the single judge are now contained at Rule 65 of the Criminal Procedure Rules of 2005 as amended. It is for the applicant to serve his renewed application on the register not more than 14 days after refusal of application. That the applicant wants to renew. The power to extend time is set out in Rule 65.3, which so far as it is relevant provides. The court or the registrar may A. Shorten a time limit or extend it even after it is expired, unless that it is inconsistent with other legislation. The rule governing applications for extending time is a person who wants an extension of time within which to serve a notice or make an application must A. apply for that extension of time when serving that notice or making that application, and B. Give reasons for the application for the extension of time. The principles to be applied by the court when considering an application for extension of time was stated in a number of cases deciding long before the present rules were formulated and, indeed, before the Human Rights Act 1998 came into force. They all emphasise that the rules are there for a reason and that the court must insist on its rules being obeyed rather than flouted. Therefore, an extension of time in which to make a renewed application will unusually only be granted if there is a good and exceptional reason for doing so. This has been held to be the case even where the reason for delay is entirely the fault of the lawyers of the applicant. We accept that we have to examine each case in light of the present rules and bearing in mind the ECHR rights of the applicants, whilst emphasising that just because the applicant has ECHR rights, that is not a panacea in all cases. As the cases say, good reason has to be shown. In this case, the reason for delay are set out in advice of Miss Marsh QC dated the 17th of October 2010, in which it stated that Miss Marsh advised after initial refusal and that the applicant said that he wished to renew his application. Miss Marsh has told us, repeating what was said in writing, that she had anticipated that the solicitors or the applicant himself would serve the renewal notice. There was some discussion about the issue and materials for the renewal, but by August 2010 no renewal had been made and Miss Marsh learned, informally, of this. She drafted a renewal application and forwarded it to her instructing solicitors on the 1st of September 2010, asking them to approve and lodge it. This was not done. Miss Marsh realised this via other counsel on the 24th of September 2010. Miss Marsh had a further consultation with her solicitor on the 8th of October whilst trying to obtain the grounds lodged by Levan Menzies. Then, on the 11th of October 2010, Miss Marsh received a copy of a letter from the Registrar of Criminal Appeals to those instructing her, asking that the position of Nigel Ramsey be notified within 14 days from the 7th of October. On the 13th of October 2010, Miss Marsh sent an email to the Criminal Appeal Office saying that she will complete the renewed application by the 18th of October 2010. In fact, the form was not received by the Criminal Appeal Office until the 2nd of November 2010. This is a sorry story of delay, coupled with a lack of any feeling of urgency, which, we are forced to say, does not reflect well on any of the advisors of Nigel Ramsey. If the application of Nigel Ramsey stood alone, we think that it is unlikely that we would have been satisfied that there was sufficient good reason to extend the time for renewal. But his application does not stand alone. We are today also considering the applications of the other three who have made their renewal application in time. There is no suggestion that those applications have been delayed by the late application to renew on behalf of Nigel Ramsey. There would, we feel, be a justified feeling of injustice on the part of Nigel Ramsey if his application was not considered on the merits at the same time as the other three. In those exceptional circumstances, we therefore grant the extension required. The applicants between them had originally proposed 6 different grounds of appeal relating to both counts. Before us all, counsel, I have asked us to consider one particular ground. We will then come to the others in due course. That ground is now particularly relied on concerns of count 2. It is that there is now fresh evidence in the form of an expert report from Mr. Geoffrey Arnold. He gave evidence in the subsequent trial before Justice Keane QC. In that trial, Daud Ahmed and Abdi Rahman Ali faced charges of assisting Denzel Ramsey in the recovery of a sawn-off shotgun that had been recovered on the 21st of July 2008 and of having it in their possession between the 11th and 18th of July 2008. It was therefore of the essence of the prosecution case in the trial that the sawn-off shotgun recovered on the 23rd of July 2008 had been the murder weapon. In the event, Mr. Ahmed and Mr. Abdi Rahman Ali were acquitted of those offences, although they were later convicted of others that were not relevant. Mr. Arnold prepared a statement for the defendants, Mr. Ahmed and Mr. Rahman Ali, in the trial before Mr. Justice Keane. He reviewed Dr. Robinson's 3 statements that had been in evidence at the first trial, He also reviewed Dr. Robinson's examination notes and the relevant exhibits with a view to commenting on 1. The ballistics evidence relating to the brand of shotgun cartridge used in the killing of TC. 2. Any ballistic tool marking showing an evidential link between the gun recovered and the death of TC. And 3. Any ballistic or tool marking showing an evidential link between the shotgun cartridge recovered and the shotgun of the cartridges recovered from 97 Norgreave Way. Mr. Arnold's first main difference of view with Dr. Robinson was on whether the cartridge recovered from the shotgun came from the same source as those cartridges recovered at 97 Norgreave Way. He said that the 45,000 cartridges of that type had been produced in the 4 years since their introduction up to the death of TC. Without supporting evidence of traces, he suggested that locating 7 of the cartridges in 2 separate locations does not equate to supporting evidence that they originated from the same source, other than the same manufacturer. His second main difference is that he did not agree on the correspondence between the wadding type recovered from the gun and from the body of TC, and that the pellet weight provided strong scientific supporting evidence for the view that TC was shot using a Lyovale Magnum Maximum Game No. 1 cartridge of the type recovered. In his view, the cartridges, pellets, and wadding are far from rare, and the pellet wadding combination could have originated from another cartridge manufacturer, not just Lyovale. Therefore, his conclusions were that number 1, that there was no conclusive evidence that the cartridge used to kill TC was a Lyovale cartridge, and 2, that there was no evidential link between the shotgun recovered and the killing of TC, and 3, that there was no evidential link between the wadding found at the scene and at the test wadding produced using the shotgun, and that 4, there was no evident link between the shotgun cartridge recovered and the shotgun and the cartridges found at 97 Norgreave Way, other than the fact that they originated from the Lyovale as similar cartridges. Trial before Mr. Justice Keane, Dr. Robinson gave oral evidence. A transcript of his cross-examination was not before us at the leave hearing, but we did have a note prepared by the counsel. It appears that Dr. Robinson accepted that when the gun was recovered on the 21st of July 2008, it was incapable of being discharged, and that this was probably due to a build-up of greasy deposits. He also agreed that he could not say that the condition of the gun would have been any different on the 11th of July 2008, when it was said to have been the murder weapon. Therefore, he could not say that on that day the gun would have been capable of firing. It transpired that Dr. Robinson had conceded this much in the third statement he had made at the time of the first trial, which we were shown. However, it is clear that this was not the case as put by the prosecution at the outset of the trial. The applicants say that the prosecution's case in closing was that the gun recovered was the murder weapon, and that they say this is a clear way that the judge dealt with the matter at pages 90 to 92 of his summing up. It appears that Dr. Robinson also said in cross-examination that he has used ammunition from a manufacturer other than Lyovale for his test firings. That might have affected his conclusions. Dr. Robinson also appears to have accepted that the fact that no gunshot residue were found and that no checks were done on swabs from the barrel of the shotgun recovered, and it made it more difficult for the prosecution to demonstrate that the gun was actually the murder weapon. It appears that in the course of counsel's cross-examination of Dr. Robinson, the judge said to the counsel, "You can't do any better," and asked Dr. Robinson if he could be sure that the gun recovered was the actual murder weapon. As a result of these interventions, counsel cut short his cross-examination and did not get into the details about the source of the pellets, their weight, the number of pellets manufactured, and other materials dealt with in Mr. Arnold's statement. As already noted, Mr. Ahmed and Mr. Rahman Ali were acquitted of the counts relating to the shotgun. The submission of all the applicants is that it is reasonably arguable that A. the statement of Mr. Arnold and B. the evidence of Dr. Robinson at the subsequent trial constitutes fresh evidence that is admissible, credible, could not have been produced at the trial, and affords grounds for allowing the appeals of all the applicants. Therefore, leave should be given on this ground at least. Crown's response is that the evidence relating to the gun that was found at Oscarthorpe Park and the cartridges that were subsequently found were not central to to the prosecution's case on count 2. The prosecution case was that the gun and the cartridge were consistent with the gun that had been used in the attack on TC, and that the cartridges had connections with those who the prosecution said were the murderers. That evidence was only one piece of the jigsaw. It is also emphasised that the fact that the murder weapon found was the gun used in the murder was an essential part of the case at a subsequent trial against Mr. Ahmed and others, that he had assisted in disposing the weapon. Therefore, the prosecution had to prove that it was such. The Crown also points out that at the time of the trial before Griffiths Williams Justice, the defence had a firearms expert who had produced a report. This was Mr. Dyson. That report was not served on the prosecution, nor was Mr. Dyson's evidence relied on by the defence. It must be assumed, therefore, that he supported the conclusions of Dr. Robinson, and so would have opposed the conclusions of Mr. Arnold. It is submitted that it is wrong in principle to permit a new expert to be relied upon at the appeal stage, unless there are exceptional circumstances, and here there are none. The cases emphasise that it is an obligation of the defence to advise its whole case at the trial, and it is not the object of Section 23 of the Criminal Appeal Act of 1968 to permit a convicted person to have a second chance to advance expert evidence that was not advanced at the trial unless there is some exceptional reason why it could not or was not advanced. In effect, here, the applicants rely on the fact that there was a subsequent expert who disagreed with Dr. Robinson in a way that the applicant's own expert at the time of the trial did not. We have not explored in detail A. the views of Mr. Dyson at the time of the trial, B. why he was not called, C. the circumstances in which Mr. Arnold prepared his evidence, D. what the prosecution knew about Mr. Arnold's evidence at the time of his trial, E. whether there was any disclosure issues that arose. Ultimately, however, we have come to the conclusion that we must grant leave to appeal on this ground. We accept that it is arguable that it would be in the interest of justice for the Court of Appeal to receive fresh evidence of Mr. Arnold and the subsequent evidence of Mr. Dr. Robinson. We are not deciding on that question, nor are we deciding any issue concerning Section 23(2) of the Criminal Appeal Act of 1968. Those will all be open for argument at the main hearing. However, it will be necessary for the applicants to consider what evidence needs to be before the full court so that it can consider whether it should receive any fresh evidence from Mr. Arnold. In particular, we think that there will have to be evidence about A. what expert evidence the applicants had available at the trial, B. why it was not used, C. whether the Crown knew of Mr. Arnold's views at the time of the trial, and D. why it was not disclosed if they did know. We order that their transcripts be prepared of the evidence of Dr. Robinson and Mr. Arnold at the trial before Mr. Justice Keane. The second ground that is pursued by all applicants is that the judge erred into giving the jury the written directions on the law that he did. It is not suggested that there are any erroneous directions of law in the written directions, but it is submitted that the judge should have acceded to the submissions of defence counsel at the trial, not to give them to the jury. The argument was that the written directions ran the risk of concentrating the jury's mind too much on the matters of evidence. Indeed, on what the prosecution's case on that evidence was, that had to be referred to in the written directions, although the judge kept those to a minimum to explain the points of law he was dealing with. The argument must be that this led to unfairness and to some disadvantage for the applicants. This is not arguable at all. It has been the practice of trial judges for at least 12 years, to our knowledge, to provide juries with written directions on the law in complex cases, and often in more straightforward ones. The judge identified 5 very sound reasons why it was proper to give them written directions in this case when he has gave his rulings on this topic. The practice of giving written directions on law is to be encouraged. This ground is dismissed. The next ground, which is advanced only on behalf of Mr. Chatu, is that the judge wrongly refused at the conclusion of evidence to add to the indictment a count of a Section 18 wounding with intent to cause GBH as an alternative to count 1, the count of attempted murder. Mr. Chatu's defense to count 1 was self-defense. He said that TC started the fight with a knife. The argument is that if, as obviously happened, the jury rejected that defense, they were left with no alternatives but to convict of an attempted murder, and so there must have been obvious pressure on them to do so in absence of an alternative count. It is suggested that the evidence of an intention to kill on Mr. Chatu's part was far from compelling. The general principle is that the judge is not obliged to leave to the jury an alternative count of the lesser offence unless that possibility has been obviously raised by the evidence, so that in the interest of justice, the judge should leave such a verdict on a lesser offence to the jury, as seen in R vs Coates 2006 1 WLR 2154. It is for the judge to decide whether the evidence requires that he take this course. The question here must be, if the jury rejected self-defense, was it obvious that the evidence raised the possibility that the intent of those involved was only to commit GBH or some lesser injury as opposed to an attempt to murder? The judge had to take a view on that. We were told by Mr. Grunwald QC on behalf of Mr. Chatu that he and counsel for Nigel Ramsey and Mr. Galloway made submissions to the judge that he should leave to the jury the possibility of a conviction under Section 18 of the 1861 Act, but he refused, without giving any reasons. In those somewhat unusual circumstances, we decided we should grant leave on this ground. We order that there should be a transcript of the submissions made to the judge on this issue and his ruling on it. Next ground of appeal on conviction we have to consider is that raised by Mr. Grunwald on behalf of Mr. Chatu and Mr. Bourne QC on behalf of Denzel Ramsey. The ground relates to count 2. It is that the description of the assailants, none of whom was formally identified by the witnesses, was at such a variance to that of the applicants in terms of his build and appearance that there remains a significant lurking doubt as to the safety of their conviction on count 2. Mr. Grunwald and Mr. Bourne submit that the evidence of Mrs. Goodlad, who was called as a witness by the defence, was important and credible evidence that contradicted the prosecution's case in important respects. First, it contradicted the prosecution's case on where the assailants had come from to get to the barbershop. Secondly, it contradicted the actual appearance of Mr. Chatu and Mr. Ramsey in almost every respect. Thirdly, her evidence suggested that 3 Asians were involved in the killing, which may have been significant given their background of a possible robbery by TC and the background of those involved in that affair. The judge set out clearly the defence case on this in his summing up at 22E and 24D. He set out the prosecution's case on the evidence of Mrs. Goodlad at page 20B and D. Dealt with her evidence in 3 places, 26BD, where he said that her evidence on where the 3 men who were the assailants came from was reliable, and he invited the jury to accept it. Secondly, at page 89A, where he has just reminded the jury of the evidence of Savannah Clark and the description of the people standing on the steps of the barber's shop, a flash, and then 3 men running past her, 2 of whom had guns. At page 89A, the judge says that the jury might like to consider that evidence when they also consider the evidence of Mrs. Goodlad. That is dealt with by the judge again at page 125A to 127B. He goes through her evidence in detail, including her evidence of the description of 2 Asian boys and another man she saw when walking back to work with her sandwiches. He reminds the jury that she did not pick out Denzel Ramsey in a video ID procedure. It is submitted that although the judge summarised accurately the evidence of the prosecution's eyewitness and that of Mrs. Goodlad, yet he erred in a way that he invited the jury to deal with the description of evidence given by the prosecution witness and that of Mrs. Goodlad. He said, in relation to the first, that their evidence was only to show that their general descriptions were not inconsistent with those of Mr. Chatu, Denzel Ramsey and Levan Mendes, whereas in fact it clearly was. In relation to Mrs. Goodlad, the judge's use of the statement that she had cleverly believed that what she had described had indeed happened suggested that the judge thought that belief was wrong. We cannot accept these criticisms produce an arguable ground of appeal. The judge put Mr. Goodlad's evidence very fully to the jury. He reminded them on more than one occasion that they had to consider the evidence with all the other evidence of description given by the prosecution witness. We are quite satisfied that the judge dealt with this issue fully and fairly. This is not an arguable ground of appeal. There were other proposed grounds of appeal on behalf of the applicants. They were abandoned before us, and we need not to deal with them all. The upshot of all this is that we grant leave to appeal to all the applicants to appeal on what we have described as the fresh evidence point. We also grant leave to Mr. Chatu and Nigel Ramsey to argue the issue of the judge's decision not to leave an alternative verdict to the jury on Section 18 on the 1861 Act of Count 1. We also give the following directions in relation to the preparation of the appeal hearing. We also said that we thought that, given the time of this constitution has already spent reading the papers in this case, far longer than the estimate of 2 hours that had been given to the exercise, it would be to an efficient use of the court time for the same constitution to hear the appeals, unless counsel objected to that, of course. None did. We announced our decision on the issue to lead the appeal on conviction at the end of counsel's submissions. We asked for counsel for Nigel Ramsey, Miss Marsh, and for counsel for Leven Mendes, Miss Rose QC, whether they had any objections to us considering the appeals against the sentence of their clients at this hearing, despite the fact we had granted leave on their conviction appeals. They had no objection, so we went on to deal with the appeals against the sentence of Nigel Ramsey and Leven Mendes. Mr. Ramsey's appeal is limited to his sentence for the murder of TC. The sentence of life imprisonment is fixed by law. His appeal is, therefore, confined to the length of the minimum term, which he must serve before he is released from prison on licence, can be considered by the parole board. Mr. Mendes was only 16 years old at the time of TC's murder, and the sentence that he will be detained until Her Majesty's pleasure be known is also fixed by law. So, like Mr. Ramsey, his appeal relates to the length of the minimum sentence, which he must serve before he is released from prison on licence, can be considered by a parole board. In the course of his sentencing remarks, the judge explains the context in which TC had been murdered. Mr. Ramsey had been a leader of the S3 gang in Sheffield, which engaged in robberies, dealt in drugs, and resorted to extreme violence in order to achieve its ends. Its members were indifferent in standards of those who want to live in a civilized society, and the rule of law meant nothing to them. Not only had TC been murdered because he had told members of one fraction of a gang where a member of another fraction was going to be so that he could be killed, but he had been murdered only a few days after an earlier attempt to murder him had failed. The effect of the jury's verdict was that TC's murder had been ordered by Mr. Ramsey from prison. It had been both planned and premeditated. The fact that Mr. Ramsey had not been there himself when TC had been shot, and had therefore been unable to direct operations on the ground, did not begin to reduce his culpability. The judge said that the fact that it was Mr. Ramsey who had ordered the murder of TC entitled him to conclude that Mr. Ramsey's culpability was higher than that of those who actually carried out the murder. Nigel Ramsey may not have given instructions about precisely where and when TC was to be killed, but it is not suggested that he did not know that a firearm was to be used to kill him. The judge also concluded that Nigel Ramsey's culpability was higher than those who were responsible for carrying out the murder, because it was Nigel Ramsey who arranged for TC's killers to get out of Sheffield. It was argued before us by Miss Marsh QC that there was no evidence that Nigel Ramsey made such arrangements immediately prior to the shooting of TC, and that the pattern of the telephone calls to or from Nigel Ramsey's mobile phone, which he had in prison, proved that this was the case. That might be so, though we note that the judge who presided over the trial of his girlfriend, Keisha Minley Donaldson, thought otherwise. But the fact is, prior to the shooting of TC, Nigel Ramsey had made arrangements for those who had been involved in the stabbing of TC to get out of Sheffield. And within a short time of the shooting of TC, Nigel Ramsey was on the phone to his girlfriend, making arrangement for TC's killers to be looked after. Miss Marsh also argued that there was no evidence that Nigel Ramsey was specifically involved in organising the weapons used, nor did he persuade Minley Donaldson to assist prior to the murder of TC. None of those points persuaded us that Nigel Ramsey's authority within the group was any less than the judge thought it was. Nigel Ramsey was 23 years old at the time of sentence. He had previous convictions for supplying hard drugs or possessing them with intent to supply, for which he had received detention and training orders. The sentences he was serving at the time of TC's murder were sentences for detection of public protection for offences of wounding with intent and unlawful wounding. There were different views relating to his behaviour during his sentence. Wing staff reported a polite, cooperative prisoner, whereas his security file was said to have numerous entities indicating assaults, intimidation, threatening behaviour and abuse. Behaviour to staff and other prisoners. He showed no signs of moderating his behaviour. The person who conducted an Oasis assessment of him was tempted to recommend that he be upgraded from Category C to a Category B prisoner. Since the murder of TC involved the use of a firearm, this was the sort of case whose seriousness would normally be regarded as particularly high, and for those which the appropriate starting point for the minimum term would therefore be 30 years. We have no doubt, indeed, it is not contended otherwise, that the judge was right to take that as his starting point. We appreciate, of course, that the minimum term of 35 years was a crushing sentence for a man of his age, but he had been an adult aged 22 at the time of TC's murder, and he had used his authority and power to order the murder of a 17-year-old youth. The minimum term of 35 years was justified in his case, and his appeal against sentence must be dismissed. Mr. Menz's extreme youth called for a different approach in this case, as did the fact that he was not a member of the gang. However, the judge described him as an enthusiastic hanger-on who was happy to be part of a murderous expedition to kill a man in cold blood. It looks to us as if he was earning his spurs. The judge could not be sure that Mr. Menzies was the man who had the second gun, and Mr. Menzies was accordingly sentenced on that basis, that he knew that the two other men were armed with guns. The judge initially thought that Mr. Menzies' involvement in the murder could have been put down to his immaturity, and in the connection, the judge noted that Mr. Menzies' intellectual functioning had been assessed as below average. But the judge had had the opportunity to observe Mr. Menzies in giving evidence. Menzies struck the judge as being streetwise, and the judge's conclusion was that his offending was explained by the criminal environment in which he had been brought up and by his willingness to be led. Mr. Menzies had a number of previous convictions, but he had not had a custodial sentence. The judge said he did not regard Mr. Menzies' record as an aggravating factor. Since Mr. Menzies was under 18 when TC was murdered, the appropriate starting point for the minimum term in his case was 12 years. That starting point applied whatever the circumstances of the murder. Unlike offenders aged 18 and over, for whom the law distinguishes between those murders whose seriousness is particularly high, for which the appropriate starting point is 30 years, and other murders, for which the appropriate starting point is 15 years. The judge was entitled to treat the fact that this was a murder involving the use of a firearm, which would have justified the higher starting point for someone aged 18 and over, as an aggravating factor which could justify a minimum term in excess of 12 years. See the Attorney General's reference number 126 of 2006-2007. In the case of Denzel Ramsey, the judge specified a minimum of 25 years. A reduction of 5 years from the starting point of 30 years, which the judge was obliged to take in Denzel Ramsey's case. The judge described him as one of Nigel Ramsey's lieutenants. Denzel Ramsey was 19 at the time of TC's murder and 20 at the time of sentence. Like Mr. Menzies, the judge could not be sure that Denzel Ramsey was the man who had the second gun, and Denzel Ramsey was accordingly sentenced on the basis that he knew that the other two men were armed with guns. The principal point of Mr. Rose QC for Mr. Menzies was that although the appropriate starting point for the minimum term in Denzel Ramsey's case was 30 years, the judge reduced that by 5 years, even though there were no particular mitigating features. Plainly, the judge did that to distinguish Denzel Ramsey's case from that of Mr. Chatu, who had been 20 at the time of TC's murder and 21 at the time of sentence. He was someone else who the judge described as one of Nigel Ramsey's lieutenants, but the judge was not sure that it was he, Mr. Chatu, who actually shot TC. The argument is that the difference of 5 years between Denzel Ramsey's minimum term and that of Mr. Menzies is inappropriate. If a 25-year minimum term was right for someone whose starting point was at 30 years, a 20-year minimum term was not inappropriate for someone whose starting point was only 12 years. It should have been a lesser figure. We accept this argument in part, but the logic of it cannot be taken to extremes. The logic of the argument is that there should have been a much greater distinction between the minimum terms simply because of the starting points were so different. That does not find support in the cases which have been addressed the difficulties which can arise when offenders of different ages are to be sentenced for murder. See in Taylor 2008, where the court said, if two offenders of equal culpability kill in the course of a robbery and one was aged 17 and a half and the other one was 18 and a quarter, the statutory starting points would be 12 years and 30 years, but significantly divergent minimum terms for the two different offenders would be neither just nor rational. In Attorney General's references numbers 143 and 144 of 2006 and 2008, the court at 27 rejected the argument that the sentencing judge should determine the sentence of each offender independently of the position of the other. The court said that where the different starting points were provided for only because the disparity between their ages, the sentence should move from each starting point to a position where any disparity between the sentences is no more than a fair reflection on the age difference between the offenders. In our view, the critical question in Mr. Menzies' case is whether the fact that this was a murder involving the use of a firearm, albeit not used by Mr. Menzies, in which TC had been deliberately targeted, justified a minimum term of 20 years for a streetwise 16-year-old with learning difficulties, who was content to join in the enterprise, but who was willing to be led on. We are very hesitant to interfere with the judge's assessment since he was well placed to evaluate all these factors, but as the single judge noted, the sentencing judge found Mr. Menzies' case particularly concerning. Our final view is that the minimum term of 20 years in the particular circumstances of Mr. Menzies' case was too long. We think that the appropriate minimum term was one of 17 years. Accordingly, we allow his appeal against sentence, and we substitute for the minimum term which the judge imposed as a minimum term of 7 years. We substitute for the minimum term which the judge imposed a minimum term of 17 years. Finally, we come to Keisha Mindley Donaldson. She was tried at the same time as Mr. Ahmed and the others before Mr. Justice Keane QC on the same indictment as them. On the 12th of October 2009, also at Sheffield Crown Court, she pleaded guilty to 2 counts of assisting an offender, and weeks later she was sentenced by Judge Keane QC to 18 months imprisonment and 3 years imprisonment on each count, those sentences to be served consecutively to each other, making 4 years imprisonment in all. She now appeals against her sentence with leave of a single judge. The count on which she was sentenced to 18 months imprisonment related to her finding an accommodation in Birmingham for the 2 men who had stabbed TC on the 6th of July. That is, Mr. Chatu and Javan Galloway. She had been called by Nigel Ramsey within the hour of the stabbing to find accommodation for them. Following a Newton hearing, the judge found that she had been aware of what had been done. She booked accommodation for them, and she was in touch with Nigel Ramsey about what she had organised. The other counts related to finding accommodation in a hotel near Wolverhampton for the 3 men who had shot TC on the 11th of July 2008, and taking other steps to assist them. Following the Newton hearing, the judge found that she had known in advance that a further attempt was to be made to kill TC. She had been called by Nigel Ramsey shortly before the shooting, since she had been telephoned by Denzel Ramsey within the hour of the shooting. That was presumably when she was told about the shooting that had taken place. Not only did she book the accommodation for them at a time when she knew that TC had been shot, but she collected 2 of the men from the hotel and took them shopping. The following day, she booked them into another hotel, but she had been less than professional in her approach, since she had allowed her mobile to run out of charge, with the result that Mr. Chatu had not been able to contact her when he wanted to. She later wrote to Nigel Ramsey in prison apologising for that. It is apparent that some of the things which Minley Donaldson did, albeit reluctantly, following her arrest on the 19th of July 2008, in fact helped the prosecution of those who had attempted to kill TC and those who had murdered him. She was driven round by police officers, and she pointed out various places where the men had stayed, as well as the shops and other locations they had visited. As a result, the police obtained CCTV footage from many of them places showing the men, and the police were also able to obtain forensic evidence in the form of Denzel Ramsey's DNA found on clothing which he had left at the first hotel in Wolverhampton. The maximum sentence on the count for which she was sentenced to 18 months imprisonment was 5 years imprisonment, and on the count for which she was sentenced of 3 years imprisonment, the maximum was 10 years imprisonment. It is accepted, of course, that the custody threshold had been crossed and that the consecutive sentences were not inappropriate, provided that the overall sentence did not breach the principle of totality. The judge did not state what his starting point was before giving Minley Donaldson credit for her pleas of guilty, but he noted that she had pleaded guilty on the date fixed for her trial, having indicated her intention to plead guilty only a week or so before. It is true that she had not previously been arraigned, but there had been a number of previous hearings, and she had every opportunity to plead guilty at those hearings. Moreover, her claim that she had not known what the offenders she was assisting had done made it necessary for there to be a Newton hearing, though the judge said that he was not going to reduce the discount which he was going to give her for her pleas on a guilty on that account. The judge said that she was not entitled to a lot of credit for her pleas of guilty. It appears as if the judge took something of a reign of 5 years imprisonment overall as his starting point. We think it is not arguable that he gave Mrs. Minley Donaldson insufficient credit for her pleas of guilty in these circumstances. Miss Minley Donaldson was 23 at the time of these offences. She is nearly 26 now. She had only one previous conviction for criminal damage, though she was in her teens. She had been cautioned for an offence of common assault and 2 offences of assault occasioning actually bodily harm. Nigel Ramsey had been her boyfriend for 2 years before he went to prison, and she still regarded herself as in a relationship with him when he persuaded her to assist those who had attacked and later killed TC. She had a daughter who was 8 years old in May 2010 when the pre-appeal report was prepared on her. She was then being looked after by Miss Minley Donaldson's mother in Wolverhampton and her aunt in London. Miss Minley Donaldson is still in denial about knowing what the offenders she assisted had done, though she acknowledged that she had her suspicions that they had done something wrong. Mrs. Bunting submitted that the judge had to consider the extent of the assistance given by the appellant, its impact, the nature of its underlying offences, and her plea of guilty and other personal mitigation available to her. He accepted that she could have indicated her guilty plea at an earlier stage, although he said that the reason she had not arranged had been stated to be the need to see whether there was convictions in the earlier trial of Mr. Chatu, Nigel and Denzel Ramsey, and Mr. Menzies. Mr. Bunting emphasised that the appellant was of previous good character and not in a gang and was a single mother. We take into account these submissions, and we also take into account the reluctant assistance which Miss Minley Donaldson gave the police. Although the prosecution described Nigel Ramsey as a very manipulative man, she went along with what he wanted her to do, and there is nothing to suggest that she felt she could not refuse to help him had she chosen to do so. The fact is, she assisted 3 men who had committed a murder involving the use of a firearm, having previously helped those who stabbed the eventual murderer victim, and having agreed to do so in advance of the murder. Sentences totaling 4 years imprisonment were tough, but not too long. Accordingly, her appeal against sentence must be dismissed. He may have only been 17, but Tariq Shabob was already a marked man when he refused to help police officers after he was stabbed in the stomach, back and hams and leg in an ambush outside his Sheffield home. It was a decision that cost him his life. 5 days later, on July the 11th, 2008, in broad daylight outside a barber shop, he was shot in the back from 2 feet away with a sawn-off shotgun. Tariq was a keen rapper who went by the street name GT or Global Threat.
Yeah, it's GD Audible T, the fucking Terror Kid, Skinny Salt remix. It's a Sheffield thing, don't get it twisted. Or to all the Sheffield folk them, yeah? Yo. Just cause I'm the skinny sort and my skin is kinda light, man always give it the biggest toll that they really wanna see me fight. And man take the piss that I make you switch, but then I hype just stirred it I fry. So expect you chip before you make me flip or before you draw for the night. All I wanna do is cut trap, make peace, make tracks and get gas as a G. But no niggas, I think I can't back beef and I ain't talking beef you can eat. More like the beef on street, when you get blasted for the wrong speech. There would have been a place where you're laying in the mattress and figure like neck, shoulder, with glasses, hoping it put you to sleep. Why? Cause GD Audible T, don't fuck about, we love to roll deep. And I'm always on street, packing the heat of the day that I get laid 6 foot deep. So it's better you watch, I can speak it if you don't watch how. Last thing you'll hear with a click click pow. I'm skinny and proud, and what? I say it out loud. Just cause I'm the skinny sort and my skin is kinda light, man always give it the biggest toll that they really wanna see me fight. And man take the piss that I make me switch, but then I hype just stirred it I fry. So expect you chip before you make me flip or before so draw for the night. Hype, don't get me mad, I've been flipping up, but it's snapping about like fags. Hype, don't get me vexed, I've been flipping up, but it's snapping jaws and necks. I got things on lock for my mind to provide. When I spit so tight, I leave a bird with a fry with a 4-5, but the line never draws side, cause it talks hype. GT, be fucking back, I'm gonna be the kid with a strap on the side of a ball sack, I'ma walk out, stamp on your face like a doormat, pick your jaws out. Couldn't do shit back, I know that for a fact. If you try to get your jaw snapped, I'm a terror kid, you can never diss. My flow's big like Mount Everest. Just cause I'm the skinny sort and my skin is kinda light, man always give it the biggest toll that they really wanna see me fight. And man take the pisses that I make me switch, but then I hype just stirred it I fry. So expect you chip before you make me flip or before so draw for the night. And I ain't gonna lie, I draw for the night. And if you get leg, neck, shoulder and eye, hoping you'll die for fucking me right. How? I just do it on the side, put up in a place with a body on my face, gloves on my hands and a ting on my waist. So the other biggest see get the colour of my eyes. I put up in disguise, I'm evil in my mind. So I bet you regret trying to mess with this guy, but this guy don't mess. You get shanked in your face so we can look in the mirror, me to get picture, wishing they can never fuck to the killer. I'm the skinny so you're a lot bigger, but don't get it twisted, my tongue's going quicker. Don't act big cause the side of your figure, cause I'm skinny but still a lot iller. Just cause I'm the skinny sort and my skin is kinda light, man always give it the biggest toll that they really wanna see me fight. And man take the pisses that I make me switch, but then I hype just stirred it I fry. So expect you chip before you make me flip or before so draw for the night. I rep S5 for a simple reason, I'm on front line every day. I was eating, shutting off things to the gibbets that I feed it. And if you're not known, best to get trains not shown, cause I'm attracted to things that are gleaming. You might get a beating, then from front line guaranteed that you're leaving. I go swollen, lips still bleeding, nose both broken so it's hard to breathe in. And I've seen a lot of snakes in the ends, you know who you are. So your boys out for the chains and claws by wear on the ends, shutting off drugs so we don't have to starve. But guess who's balling now? I'm not arse. I keep chatting shit behind my back store. When you get blasted, already left scarred. Just cause I'm the skinny sort and my skin is kinda light, man always give it the biggest toll that they really wanna see me fight. And man take the pisses that I make me switch, but then I hype just stirred it I fry. So expect you chip before you make me flip or before so draw for the night. Just cause I'm the skinny sort and my skin is kinda light, man always give it the biggest toll that they really wanna see me fight. And man take the pisses that I make me switch, but then I hype just stirred it I fry. So expect you chip before you make me flip or before so draw for the night. Yo, it's G.T, aka Terror Kid. Gonna do a little video on that from MySpace and B-Boy, you gets me? Alright then. We got all youngers, all olders, all chef lads, nothing long, going on fucking Tez, going on Scatter, fucking Arabic master, gets me? Alright then. Yo, green eyed monster, yo, Terror Kid, yo. It's me, innit, but I ain't no bear. G.T, you must know me, surely I'm so sick I make a pussy go look poorly. I'm Tez, just like Minister for fuck's sake, listen up, mate, I'm going on sick like chaos and sinister. Just like the zoo boy, you're the minister like Merkers. Pick a breath up, panicking, but come with a wetter the size of a mannequin like Sphinx. I'm known as a king trying to war with me, you must be snorting this thing. Put the wetter to your neck to shine it like blink. Coco, summer ground like a tree to remember me. It begins with a G, in the middle is a dot and it ends in a T like sparks. You were murking the scene, it's big youth camp, I know you heard of my team like grimy. Flow sick like Kano. I love pum pum, you love anal. And if you got beef with me, you best lay low. Cause I bust more shots in the game with Halo like AK. I'm a soundboy killer and waste. Man get yam like dinner in a crash. You get slew. I cause more chaos than World War II. When I make a pussy run faster than a Zulu. Like Tracy, I'm hot like heat waves. I leave a bread drawing. Peace days, rude boy, shut your mouth, stop snorting. I've had enough of all the bullshit you've been talking. You can't step to the team. I'm the sickest MC you've ever seen. Rude boy, I don't mean to be rude. Step on the set, you get sued then brewed. It's like, down who the fuck are you grilling? You need penicillin for the bars that I'm spitting. Drop a 16, make your head start killing. Don't really care about the crews that you've been in. I go to your bash, have a clash and I'm winning. Okay, you're the stupid. If you wanna clash with me, you get snookered. Your family plus your crew was included like tested. You get laid like flooring and took a bear with the wetting and it was pouring. GT, I'm that terror kid, me, no one ever did. Rude boy, shut your mouth, stop praying. Cause I switched on a bitch like I was super saiyan. Roll with a metal like Captain Hook. So if you want it, bear, prepare to get jumped. And if you got boys, it's so gravy. If you want war, I call on my navy. Been a soldier from about baby. Was are so deep, they're about 6 feet. If you want war, waste man, that's me. I'll injure your jaw so much you can't sleep. Anyways, let's get the place jumping. I like music like rasses like dumpling. Green eyed monster, evil bread. Spitting on the level that no one can compare. You get aired, left prang and scared. And like paper, you don't wanna get teared. GT, beef I come back. I've run up in your crib with a strap at the side of my ball sack. I'm a walk out, stamp on your face like a doormat. Where your jaw's at, couldn't do shit back. I know that for a fact. Even if you tried, you get your jaw snapped. I'm a terror kid, look to get violent. Never stay silent, hit the police, always running from the sirens. Yeah, yo, I'm like, yo, this is how I drop it. Flipping on pussies, I'm on a rocket, stop it. You know where your head top flying like a rocket, pop it. Sucking back cash, now you ain't got it. I was on road with the webs in my pocket. Give me an ounce 2 days and I shot it. It's like, yo, it's G.T on a lyrical B-flex. Call my name and you might have to be next. So I think you shouldn't get me vet. I break necks, whole textbook, have a safe sex. And I had your girl sucking cock. Bent over but put her in a back shot and a lock. Bitch got popped, hook couldn't stop. Then she got drilled outside of the shop, I was like, no name calling, you sound appalling. Spit same bars every time you're recording, gets kinda boring, so I start yawning. Please shush before I start snoring. And don't act it cause your flow is quick, cause your rhymes are shit and I murk your prick. So take my advice and watch your lips. Yo, I'm like GT, I bring terror, I'm a global threat to your end of your tether. Don't get clever, cause I switch on bitches and start spraying like pepper. You better never spit like you're sick, your whole clique get ripped like leather. Or you get murked on beat a acapella. Yeah, G'd up fucking T. Big up all youth camp man them. Big up all fucking youngers, regiments and the regime. The rest of them you get smacked. Big up fucking Jerry from fucking camera and that. Nothing long, G'd up fucking T. Blah.
And had acquaintances in Sheffield's rival Postcodes gang, S3 and S4. Could South Yorkshire police have done more to protect him? Tariq's grieving father, Rashid Chabob, says yes, but an independent investigation has found that detectives worked diligently on the stabbing case, only to meet a wall of silence from the community. Mr. Chabob claimed that South Yorkshire police only took the stabbing seriously when it was too late and after his son had been murdered. The Independent Police Complaints Commission, the IPCC, has taken another view, however, and will announce that it has not sustained any of Mr. Chabob's complaints against the force. The watchdog's findings, seen by the local papers, show that 2 officers were at the scene of the stabbing within 4 minutes of Mr. Chabob dialing 999. Tariq claimed he had been jumped on from behind and did not know who attacked him. Officers asked him more questions at his house, in the ambulance and at the hospital, but he appeared unable or unwilling to give details that would help them. The IPCC found that the officers then liaised with a team of detectives investigating another stabbing to see if there was a connection. There was little intelligence to suggest that Tariq's life was in danger. Officers claimed that they tried to help Tariq, even offering to have an alarm or a camera fitted to Tariq's home. Mr. Chabob has disputed this, and the IPCC found that the police kept no record of the offer. Detectives could have pursued some lines of inquiry more vigorously, the IPCC concluded, and they may have gleaned more information if they had interviewed Tariq while his father was present. But investigators were satisfied that police had already begun forensic and other work in relation to the stabbing before the shooting occurred. 4 men convicted of Tariq's murder were Michael Chatu, Denzel Ramsey, Levan Menzies, and the gang leader Nigel Ramsey, who was at the time a serving inmate in Wolves prison, was able to orchestrate the killing using a smuggled mobile phone. Mr. Chatu and Nigel Ramsey were also found guilty of the attempted murder in relation to Tarek's stabbing, along with Javan Galloway. The IPCC Commissioner, Nicholas Long, said, "My sympathies go out to Tarek's father and his family. He tried to do his best for his son, and his sense of despair at what Tarek had become involved in was evident." Within the space of a week, he had to deal with him being badly injured in a stabbing and then murdered. It is entirely understandable that one of his reactions was to question whether South Yorkshire police had done enough. However, the fact that Tarek was associated with this gang culture may have influenced his response to police questioning when he was stabbed. It is clear that he and his friends did not cooperate or assist the police investigation. Our investigation has shown that the officers were following lines of inquiry, speaking to the relevant people, and checking intelligence. With hindsight, some lines of inquiry, such as Tarek himself, could have been pursued more vigorously, but after his initial unwillingness to assist the investigation, he was not spoken to again in the 5 days before his murder. South Yorkshire Police declined to comment on the IPCC's findings. After the murder had taken place, every morning in the week following, the suspected most powerful drug dealers in Sheffield were woken in their beds at dawn and hauled away by the police in what was known as one of the biggest operations to tackle the city's drug and gang culture. Operation Mac, which ran for a number of weeks, aimed to snare about 100 individuals, many of whom are self-imposed role models who entice vulnerable young gangsters into a lifestyle of crime. The huge police operation would never have taken place, however, if it not for the work of South Yorkshire's police superintendent Peter Norman, who said after the murder, "Enough is enough," after teenager Tariq Chabot and Jonathan Matondo were shot dead in the Bungreve area of the city in 2007 and 2008. Their deaths signified a spiralling gang problem in Sheffield, with the city's two most prominent Postcode gangs, the S3 and the S4 crews, not afraid to kill over the most petty of differences. Superintendent Norman said, "We are aware of a small gang problem, but we used to say that things were isolated incidents. After the shooting of Tariq Chabot, I put my head above the stand and said, we aren't taking things seriously, and we should and could. I got a lot of support, so we sat up, took notice, and put a lot more resources into it. That's why Operation Mac has gone ahead. Hopefully, this will be the sparks that set things into motion." Tariq was just 17 years old when he was shot at Frenchie's Barber in the middle of the summer's afternoon on July 11th, 2008. His murder was ordered by the S3 gang leader Nigel Ramsey from his cell in HMP Wolds, following a near fatal stabbing of Mrs. Ramsey's cousin, a fellow S3 member, Junior Bam Bam Liversidge. The S3 gang had previously split into two fractions, a feud that was responsible for the fatal nightclub stabbing of 23-year-old Brett Blake in June 2008. Two friends of Mr. Blake's killers then stabbed Mr. Liversidge the day after Mr. Blake's funeral. Tariq, who had a foot in both camps, was branded as a traitor by Mr. Liversidge's camp and was stabbed within 24 hours by Michael Chatu and Javan Galloway. Despite suffering injuries to his liver, he survived the stabbing, only to be shot in the back 5 days later by one of three hooded men: Chatu, Nigel Ramsey's brother Denzel Ramsey, and Mr. Levan Menzies. All five denied the charges but were found guilty by a jury. The four convicted of murder were jailed for life, while Mr. Galloway was sentenced to 9 years. 16-year-old Jonathan Matondo, who was also an S3 gang member, was shot dead at Nottingham Cliff Recreation Ground in October 2007, less than a year before Tariq was killed. Nobody has been ever found guilty of his murder. Jonathan, who was also known as Venomous, had arrived in Sheffield in 1999 after fleeing the Democratic Republic of Congo with his mother, Teresa Mafilu. He was a keen churchgoer who had considered entering the priesthood, but by the time of his death, he had become embroiled in gang culture. When he died, Jonathan was on a supervision order for robbery and had been in trouble with the police several times previously. Although his killer has never been found, police believe it was a member of the rival S4 gang. Superintendent Norman said, "The case of Jonathan Matondo is not a closed case. If we do get any new information, it will be immediately looked at, and we're always making advances in forensic technology. The tragic death of these two young boys were a massive wake-up call. Since then, we've done a lot. New data I received shows that the serious youth violence in South Yorkshire has reduced by a fifth in the last 6 months. The visionary activities seem to be working, and I'm confident that these latest arrests will make a huge difference. As well as removing the gang leaders and diverting youngsters from a life of crime, Operation MAC also aims to help those addicts dependent on the city's drug dealers. Agencies such as Sheffield's Drug and Alcohol Action Team have been working with the police to show addicts where they can get help. A former heroin user who has become a drug treatment worker commended the police's hard-hitting operation. The 32-year-old grandmother, who has now been clean for 10 years, said, "I started using drugs when I was 15. I wasn't living a life, I was existing." It's fantastic what the police are doing because it forces people to make the choice and shows them that there is amazing free treatment that is available to them. Thank you for joining us today. What are your opinions on the crimes committed by the members of the S3 gang? Do you believe the sentences were too harsh or not harsh enough? Please let us know what you think in the comments below. Thank you for joining us today. If you enjoyed this content, please don't forget to like and share. And if you're new to the channel and want to see more Street Crime UK content, hit subscribe and press that bell so you can join us on the next video. Thank you for joining us, and until next time, stay safe.